Good afternoon, everyone, and welcome to the Christian School of Public and International Affairs. I'm Amanda Jamel, I'm dean of the school, and I'm so happy to see all of you here for the Dean's Leadership Series. One of the primary goals of this series is to give Princeton SPIA students the opportunity to hear perspectives and insights from all over the world. This semester alone, we have welcomed the head of a global NGO who was raised in Nigeria, a former American ambassador to the United Nations, the head of a congressionally funded foundation that advances democracy worldwide, two former assistant secretaries in the U.S. Department of Education, and a former Indian diplomat serving as a special envoy for digital and emerging technologies at the UN, all of whom have given our students much to consider. Today, we return our attention to Europe. Adam Bodnar is a senator of the Republic of Poland and a member of the Parliamentary Assembly of the Council of Europe. He previously served as Poland's Minister of Justice, its Commissioner for Human Rights, and its Ombudsman. In addition to his governmental roles, Mr. Bodnar is a professor of law at SWPS University in Warsaw. Although Mr. Bodnar's areas of expertise focused on his native Poland, what he will talk about today is highly relevant to many places around the world, perhaps even here in the United States. Drawing on his experience defending civil liberties and confronting democratic backsliding in his homeland, he will discuss constitutional governance, judicial independence, and the challenges of restoring democratic institutions. This timely conversation will offer us an insider perspective on protecting democracy under pressure. A few brief reminders before we begin. Please listen respectfully, remain calm and curious. And if you're inclined to engage with our speakers, please ask questions and don't give speeches. Challenge ideas and not people. Allow space for other voices. And please give our speakers the courtesy of your undivided attention. Thank you to Adam Bodnar for joining us and to everyone in attendance for today's event, which is made possible by the Johnson Leadership Fund. And thanks as well to Princeton SPIA faculty member, our very own amazing Kim Lane-Shepley, who will moderate this afternoon. Kim, the floor is yours.
Oh, great. Thank you. Thank you. It's so great to see a full house here because what we're going to be talking about today is important for Poland, but for all of the countries that have experienced democratic backsliding that are now trying to get over it. So what I'm going to do is to walk you through some of the experience of Adam Bodnar, our special guest, before we get to the topic that I think will be of the most interest, which is what do you do with a backsliding government when it's happening and how do you get over it? Adam Bodnar has been a key figure in all of that. But let me start with how Adam Bodnar got to where he is. And so one way to describe Adam Bodnar is that he's an academic who went into public service. But if you go back farther in his career, he was basically a human rights defender who decided to go into academia. So in the 1990s, he was very active in something called the Never Again Association, which was an anti-racist group in Poland. He became deputy director of the Polish Helsinki Human Rights Foundation, a member of the board of directors for the UN Fund for Victims of Torture, and more. So what brought you to human rights, and then what got you into academia from there? Because we're going to have a lot of people in the audience who may be going into human rights, we hope. So how did you do that?
First of all, I would like to thank Madam Dean, Mr. Dean, and Professor Kim Lane-Shepley for invitation. It is really like a great honor for me to be here. I'm for the first time at the Princeton University, so it's a great opportunity to see this beautiful place, this oracle of the world wisdom and ideas. My track as a lawyer was such that after finishing my law studies, in fact, I was working for a law firm that was it was the American law firm with its offices in Warsaw, Wales, Gottschall and Menges. Right now it's Wales. And basically I was doing like completely different things. So it was private equity, mergers and acquisitions, capital markets. But I was fortunate enough to meet great scholars, mentors who kind of pushed me into some other direction of my life. And I think that the most important person at that time, it was 2004, was Professor Wiktor Osiatyński, who was in fact quite well educated, and he was a lecturer at a number of American universities. And at certain point, he said that, listen, what we need in Poland is the program of strategic litigation. And to be honest, I didn't really know what is strategic litigation, although I had some previous background in human rights and in constitutional law. But basically, I looked into some practices, and I realized that it is the moment, in Poland especially, to approach human rights in a strategic way by using litigation of cases before both domestic courts and mostly European Court of Human Rights. And basically, that is the moment I started my work for the Helsinki Foundation for Human Rights. And I was sharing this work with academic work. And it seems to me that the collection of different experiences and also some, let's say, international perspective of my work helped me later on to develop in this. Maybe I will just mention one case. I was dealing a lot using freedom of information laws that had some, let's say, American relevance. It was the case concerning the placement of the black site of the CIA black site on the territory of Poland. So that was quite interesting case from many different angles. You know, thanks to this case, I could met people from ICLU, from Human Rights Watch, from Open Society Justice Initiative, number of American Constitution Project. A number of people who are kind of also dealing with the investigation of this case, but it was just one of many topics. But I think that was the most international topic at that time.
Yeah, this was, for those of you who are too young to remember, the War on Terror. One of the things the U.S. did was to have these black sites where people were picked up from all over the world and taken there for what was called enhanced interrogation, which most of the international bodies that looked at this said was torture, and one of them was on the side of Poland. There's also one in Lithuania, one in Romania. And the Court of Human Rights in Europe sided with the people who had been tortured in these sites. And the governments of those countries, even though they were US sites, right, had to pay reparations to the people who had been tortured on their sites. So as we think about US policy abroad, it actually has an effect. And then the human rights litigators in these countries can sort of get to those questions. So now, so you were doing, so one thing I should say for anyone who hasn't ever worked in Central Europe, you look at somebody's CV and you say, well, wait a second, how did you do this and that and the other thing? And the answer is you're doing them all at the same time, right? So you're starting to do this, you're getting a PhD in law at the University of Warsaw in 2006. You're litigating all of these cases as a human rights defender. And then this fateful moment comes in 2015. This is a year when it turns out to be the outgoing Polish parliament confirms you as the ombudsman of Poland. You know, we don't have an ombudsman in the US, so what does the ombudsman of Poland do? Like, what is that job? And how could you do it? You did it for 6 years through a very difficult government.
No, in order to understand what is the ombudsman in the structure of the government of Poland, I think we should come back a little bit to 90s, because 90s was the so-called third wave of democratization in Central and Eastern Europe. So basically, we had the transition in '89, the fall of the Berlin Wall, roundtable talks, Lech Wałęsa, who became the president of Poland. But at that time, not only in Poland, but in all other countries of Central and Eastern Europe, the system of government that has been created was not only based on division of powers, but also on like a system of some additional checks and balances on different powers. So it means that in every country there was a strong constitutional court, supreme audit chamber, but also some additional institutions like National Broadcasting Council, but also the ombudsman. So the ombudsman, and in Poland, the institution of ombudsman is of special relevance because the first ombudswoman, in fact, Professor Ewa Łętowska, she created like the office by her personal energy, communication skills, and also by showing that that kind of office is useful. So what is basically the role of the ombudsman is to intervene on behalf of citizens when they, but also for individuals when their rights are violated before authorities. So it is kind of like the intermediary between the between citizens and state authorities. But importantly, this ombudsman is not only just talking about those cases, it has right to join court proceedings, it has right to send some general recommendations to ministers, asking them for answer. It has also a right to monitor different places of detention. And also, there are also some international possibilities to act. But Professor Łętowska, in fact, she kind of created this office. And when I became the Ombudsman of Poland, the Office of Ombudsman counted 300 employees, really dedicated civil servants to the issue of human rights, and it had really like a very strong recognition in the Polish constitutional landscape, and also quite an important institutional legitimacy because ombudsman is appointed upon the consent of both chambers of parliament. So there is a requirement that people who are selected are having some level of trust, and sometimes it happens that it is difficult to select the new one because there are some tensions between two chambers of parliament. My situation was a little bit different because I was kind of promoted by the group of civil society organizations. So there was like a coalition of more than 50 NGOs that proposed me as a candidate. And because we did quite interesting and quite novel campaign, why the strong ombudsman is needed in Poland, what are the changes that should be promoted. Somehow politicians managed to agree on selection, and they voted for me to become the ombudsman. But what was important is not only this moment of selection, because it was like important change in my professional development, but important is that just 3 months later we had a substantial change in the government. So we had parliamentary elections, and the new political party came to power that, to put it shortly, wanted to build Budapest in Warsaw. So that was like the slogan that was promoted at that time.
It's literally
by
their slogan,
Law and
right?
Justice Party.
Right, after Orban had already crashed the democracy in Hungary. So the Law and Justice Party, which goes by the Polish acronym PiS, which doesn't mean like peace as opposed to war, it's PIS. So the PiS party comes to power first in a presidential election in 2015. Then they also get the parliament. So they have the hat trick of not just, having to be able to pass legislation through both chambers, which was unusual in Poland. Usually these governments were coalition governments. First time you get this party that is devoted to bringing autocracy to Poland. And you're the only one who's in the independent office that can actually challenge this government. So how did you approach your job once you didn't have sympathies in the parliament, in the parliamentary majority, or in the president's office? How did you defend rights that were all being infringed?
It is true that in this institutional sense, I was at certain point like the only institution that was like openly fighting for rights and values. But if you look broader, you maybe in institutional sense you were single, but you could be supported by opposition parties.
Mm-hmm.
You were supported by the civil society. There were also some activities made at that time by the Supreme Audit Chamber that were quite important from the point of view of human rights. But most importantly, you also had there was this European dimension, and I think that we will talk about it maybe later on. But somehow, like this personal feeling is that you simply believe in certain values. You are educated that the state should be based on on allegiance to the rule of law and to the protection of rights. You have the mandate that is given to you by the parliament. You have this duty to perform as the ombudsman for 5 years, and basically I remember this. I was quite often repeating this, that I was swearing before the parliament that I will duly serve as the ombudsman and represent interest of the Polish people. So, but I think what was important in context of my service was not just saying that I will do my job as best as I can, but I think it was important to use the energy of other people, especially of the civil society, to inspire people with whom I work. So quite interestingly, right now, my good colleague, who was the head of the Constitutional Law Department, is right now the Data Protection Commissioner, which is quite an important function. And then basically a number of people with whom I worked moved into different important directions in the operation of the state. But I think important aspect was to be quite imaginative in terms of how to do things. So not just to make like statements that, I'm against a certain policy, but for example, to join different kinds of cases, to present argumentation, to delay some process of changes. And also what was quite important at a certain point was that, that people who became clients of the Ombudsman office were not just regular citizens, but also, can you imagine, judges and prosecutors. So if judges were subject of different disciplinary cases, if the judges were suspended in their position, if prosecutors were subject of different kinds of legal harassment, it was also the job of the Ombudsman office to take it into account, not mentioning like, let's say, traditional clients like vulnerable minorities, like people that are affected by this illiberal government.
So maybe we should talk a little bit about what the Polish government did, like what you were up against, because I think, many people in the room will know that Poland had, shall we say, some democratic challenges to what was happening. But what concretely did they do? They started, right, with the Constitutional Court. And let me just say, those of you in my class all know this, but those of you may not. Many governments around the world, especially ones coming out of dictatorships, create a special kind of court called a Constitutional Court, different from the US Supreme Court, because that court only hears constitutional cases, and it is the only court that can resolve constitutional cases. So when an issue comes up that raises a, shall we say, an unsettled constitutional question, the case will be referred to that court, and depending on the way the jurisdiction is set up, individuals can then bring cases to that court if they haven't found vindication of their rights in other courts. But it's just imagine if the US Supreme Court had only the constitutional part of what it does stripped out and put in a separate court. So that's what that court does. So Poland has a Supreme Court, which is the highest appeals court, and also a constitutional court with this specialized jurisdiction. So if a government's going to come in and violate the Polish Constitution, one of the things it might think to do is to disable the Constitutional Court, which is the thing that can say what it's doing is unconstitutional, right? So right off the bat, in month one of this peace government in 2015, what did they do to the Constitutional Court? It's quite a story.
Oh, it's quite a long story but the short version is, I think, packing in the court with loyal people. And also abusing some procedures in order to make this packing in as effective as possible. Yeah. And also blocking the Constitutional Court from any possibility to review laws that would undermine this procedure of blocking. Yeah. So the end result was that if you compare the situation between the end of 2015 and the end of 2016, within a year, the Constitutional Court was already under the leadership of a person who was fully loyal to the leader of the Law and Justice Party. Even to that extent that later on, there were some interviews in which leader of the Law and Justice Party, Peace Party, started to say that this president of the Constitutional Court is his personal discovery, and that she's a great cook, and she likes to see her, when she's making nice evenings, nice dinners. So to that extent, you should kind of understand the level of relationship. But why was it needed? Because it was important to install this judicial review, because thanks to this, it was possible in 2016 to adopt a number of other legislative changes affecting prosecution office, secret services, civil service, and public media. And public media, I should underline here, were important because due to the coverage, especially in rural areas, public media have important influence on the way how people think and how people react, understand the political reality. So 3, and later on in 2017, the change started to affect common courts, including the Supreme Court, so the other apex court in Poland. But that is why it was so important to install this judicial review mechanism, because it opened the window for other possibilities and limited the influence. And please look, as Professor Szepel has said, because there was a strong cooperation between the both chambers of parliament and the president, it was quite easy to pass laws. Sometimes it happened that laws concerning some institutional issues, including the Supreme Court, were passed within 3-4 days from the moment of announcement. So you could see like a huge abuse also of the legislative process. And at that time, at this moment, and especially 2017, 2018, the only possibility was protest on streets, plus using maybe some other possibilities of petitioning or maybe litigating cases, but still it did not stop the process of this ongoing crippling change of the system of government in Poland.
Yeah, one of the things that is just for those of you who were following that, one of the reasons why they get away with it, these autocrats, right, is that they use often very technical legal means for doing so. So at the beginning, when the Polish government was disabling the Constitutional Court is regulated by statute. So a lot of its internal procedures are given by an ordinary statute. Here you've got a parliament that can make an ordinary statute from morning till night. They changed the system of procedure within the court, for example, so that before they could pack the court fully, they passed a statute that says in order to overturn a law, the court now needed 2/3 of the judges instead of a simple majority. So that meant that you could pack it more easily. They passed a rule that basically said, and the court has to take cases in the order in which they come in. So all the new changes went to the back of the list, right? So it was stuff like that where, it's really hard to get people to the streets on what order a court has to hear cases in, but it totally disables the institution. The institution then at the beginning fought back and declared some of those laws unconstitutional, at which point the government refused to publish the decisions of the court. And under the law, the decisions only take effect when they're published. It turns out, imagine if the decisions of the US Supreme Court had to be published in the Federal Register, not run by the Supreme Court, but run by another branch. The other branches control the publication of the court decisions. So they just nullified all the decisions of the court, just to give you some sense of how legalistic this thing got at the beginning and how quickly they were able to use these mechanisms, right? So
maybe I will just give you one example that sometimes it was really at a very sophisticated level.
Yeah.
So we have an institution which is called National Council of Judiciary. It has been created in 1989 as a major organ representing judges and fighting for their or safeguarding their judicial independence and impartiality of judges. And it is composed of 25 members. And it is kind of like the hybrid type of institution in which you have members of parliament, you have presidents of apex courts, you have representative of president, minister of justice, but you have altogether 15 judicial members, so 15 judges who are elected to this National Council of Judiciary. Okay, so out of 25, 15 are regular judges. And it was always like this, and it was even projected by Kaczynski, even himself, and other,
the leader of the Peace Party.
Exactly, in '89 during roundtable talks. So it was projected that those 15 members are elected by peers, so by other judges. So there is some kind of internal selection, and we are selecting the best ones in order to serve in this National Council of Judiciary. And the parliament, but the constitution is not specifically mentioning this. Okay, so the constitution is using one word, which is that those 15 members are elected from the whole group of judges. So what the parliament did, passed the law saying, okay, but maybe it is our task as the parliament to select those 15 members out of all the judges. So let's create a procedure. Please give us candidates and we'll select 15 out of them. Okay, so please look, like a small thing, which was obviously unconstitutional because it was against the spirit and against I would say original meaning of the Constitution. But it has been later on implemented. And of course, those 15 members that have been selected were people more or less loyal to the ruling party. And later on, the whole process of judicial appointments that were flawed, that were constitutionally questionable, started. So this National Council of Judiciary started to operate in 2018. And throughout this period, there were hundreds of nominations, and sometimes it was quite obvious that those nominations are made in accordance with, let's say, some political expectations. So I mean this that in this, let's say, that using certain techniques in order to achieve effect was quite symbolic for the government at that time. So sometimes you have this feeling that you are reading the law not just to learn what is in the law, but basically what is the effect the law is going to achieve. Because sometimes it may seem quite neutral, but then at the end of the day, you could feel that what the drafters intend and how they are going to achieve. But of course, from the point of view of regular voters, regular observers, it is extremely difficult to follow it. Okay, so even if you are a really skilled lawyer, even if you are a great public commentator, it takes you at least 2, 3, 4 sentences in order to explain. People are already lost after the first sentence. Okay, so that is how it was achieved, and it concerned all different other institutions, but in the judiciary especially, it was made this way.
Yeah. So this is exactly how the Polish government proceeded. It was how the Hungarian government proceeded before it. All these technical legal changes that disable all the checks on power. And the Council of the Judiciary, we should say, they're the ones who appoint the judges. They're the ones who promote judges. They're in charge of judicial careers. So once you capture that body, the whole judiciary is open to manipulation. And actually what was so lovely was you in the Ombudsman's office, also civil society groups, started paying attention to who are the new judges being appointed through this corrupted process. And so they're all called like neo-judges, fake judges. They're always marked, and in the sort of objective and opposition press, they're referred to as the neo-judges or the fake judges. So you know exactly which ones they are, which was incredibly effective, actually. And so now let me so I want to actually linger a little bit on your ombudsman time, and I want to come forward to the question, what happens with Adam Bodnar? He's the ombudsman through this period, the only one who's kind of bringing litigation, the only part of the government that's not really captured eventually by the time the ruling party gets around to making all the other parts of the government loyal to the government. He's litigating. Okay, finally there's an election, he becomes justice minister and has to undo all this. So hold on, that's what's coming, because coming soon to a government near you may be the exact same problem, right? Of how you unpack institutions that are packed. But let me linger a little bit on your time as ombudsman, because one of the things you could do was to make a lot of public statements, which you did, to mobilize civil society and give it a focal point for organization, which you did. A lot of defense of the judiciary, which you were doing the whole time. And you were also encouraging the Polish judges to go to the European courts for assistance. Okay, now maybe I can explain a little bit, because we have an audience for whom the EU is, you all know it's there, you don't know what it does probably legally. Okay, so let me just explain just one technical thing, and then I want it over to you on what the Polish judges did. So if you're a member of the EU law is supposed to be applied by your national judges. Okay, whenever a question arises that touches on EU law, the national judges are in charge of applying it. If a national judge feels like there's a question of EU law that is uncertain or not settled, it's the same procedure that you use, like I just described, for the Constitutional Court. You pause the case, and then you send the case to the Court of Justice of the European Union, the European Court of Justice. You pause the case, you wait for them to come out with an answer, and then you bring it back and apply it, okay? So it turns out, as this was happening in Poland, as everyone could see, it was also happening in Hungary, by the way. Court of Justice had its hats on fire, like they could see that if the judiciary is corrupted, you can't enforce EU law, right? Because the judge is loyal to an autocrat are not really going to be all in favor of European values, right? So they're looking for a way to dive in and help the judges. So as you explained, actually, we just did this, I'm going to do it faster. There was a case that came out of Poland. The judges' salaries have been reduced along with everybody else. They say this is a violation of our independence. Court of Justice uses this case to say, since all the national judges are also EU judges, we can insist that the judiciary in every member state is capable of enforcing EU law and delivering, the buzzword is effective remedies, Article 19, Part 1 of the Treaty on European Union. Okay, so they come out with this case in Portugal. And then the Polish judges start. And so we want to pick up the story about the Polish judges. ECJ is saying, bring us cases on judicial independence. And so over to the Polish judges.
Okay. I think in order to supplement the story, I should mention one thing, because there was one moment, it was summer of 2017, when it was interestingly just after the visit of Donald Trump to Warsaw, where he was really greeted with crowds and with the land justice government, that government has proposed and passed really quickly laws concerning the Supreme Court and the National Council of Judiciary. But interestingly, people really protested heavily against those laws. So there were demonstrations taking place in more or less 200 Polish cities. And interestingly, President of Poland, right-wing President Andrzej Duda, decided to...
Who was here in the fall, by the way. This is your other opinion on Poland.
So he decided to veto those laws, which was quite... you can imagine that it was quite controversial on the right side of the political scene, but it seems to me that it was really that those protests were so massive and so powerful that he didn't have any other option at that time. And why I mention this? Because it was a little bit like the moment of transformation for Polish judges, because they realized that they have to do something more in order to fight for their independence. So from that moment, they started to engage a lot into different educational programs. Can you imagine that, for example, Polish judges regularly attend music festivals where they organize some, in some camps, mock trials, and just explain to people what does it really mean to have a fair trial. Mm-hmm. So it happened just after this 2017, or that they are, making different lessons on constitution, on adjudication of cases in public schools. So basically it started all of this after 2017, okay? But there was also another strategy, which was the strategy of litigating cases in such a way as to achieve good judgments coming from Court of Justice of the European Union, which is this kind of a Supreme Court for the European Union. But also in order to get judgments of the European Court of Human Rights, which is a little bit different institution, because you cannot turn to the European Court of Human Rights like in the middle of the case. You have to finish your case first in a country and then go to the European Court of Human Rights in Strasbourg. But basically they kind of created different strategies that if they have a case on their desk, which is having some EU element, so some element of the application of the EU law, they will start the case, they will pose the case and ask so-called preliminary reference question to the Court of Justice of the EU. But at the same time, they were advocating for the European Commission, which is kind of a government for the European Union, to also start so-called infringement actions against Polish government. So it is another way to get to the Court of Justice of the EU. And if you look back between 2018 and 2021-22, you had like number of cases that in which the Court of Justice was evaluating different aspects of domestic laws concerning Polish judiciary. So, for example, the special chamber of the Supreme Court, so-called disciplinary chamber, has been disqualified as being contrary to the EU law.
I just put in one of the judicial reforms is the government put in these two new chambers, like little panels within the Supreme Court. One of them was just to discipline judges, and the Council of the Judiciary would send references to that court saying, punish this judge for ruling against the government. Okay, just so you know. Okay, so then the Court of Justice says, but there's some problem with that.
So in fact, as a result of those preliminary references, the Court of Justice had the opportunity to evaluate the system of judiciary in Poland and all those legislative changes. I don't want to go into details, but in my opinion, like looking back, what was important is that Polish judges could count on something like a solidarity effort from other colleague judges from other member states, but also from those EU Court of Justice judges, but also that this whole process of litigating cases delayed the process of changes in Poland. So the government started to realize at a certain point that if they want to implement some policies at the EU level, and these policies are very important also money-wise, it is quite difficult to make it in a situation when you have this pending rule of law crisis. So at a certain point, this pace of reforms was not so high as in the beginning. Moreover, as a result of this judicial reforms, you started to see people who became kind of like public heroes for their integrity, for their judicial resistance. So there were especially 3 judges who were suspended in their role as a judge by this disciplinary chamber. So presentation of them publicly became like a symbolic in terms of resistance, but also encouragement to others to protest and to be consequent in this protest.
Yeah. So the judges are on board. The judges are doing these public education programs. The suspended judges are being greeted with huge crowds. Big civil society initiatives also. There was a point when the Polish government fired the president of the Supreme Court. And she refused to say that she was fired because she claimed it had been unlawful. So she shows up at work on Monday, I think it was, with several hundred supporters that sort of guide her into the building. Civil society folks showing up. There are all these people. Those of you in my class will see that when you open your Canvas page, the first page is all the demonstrators with the signs that say Konstytucja, which is the word for constitution, and highlighted in it are the words you and me. Because they're little pieces of that word. And these were all these public demonstrations in favor of the judges. There was even a march of the judges. I think you might have organized that. But you right? And so there was a march of judges, all the judges, and also from all over Europe, showed up in their judicial robes and marched through the streets in defense of the judges, right?
Maybe once again, I told you about this like a legislative technique of achieving a certain change, a certain political change through theoretically neutral provisions. So with the president of the Supreme Court, the situation was like this. In Poland, judges of the Supreme Court, the age of retirement was 70 years old. Okay, so the parliament has decreased the retirement age to 65. It means that the president of the Supreme Court, who was still having in front of her 2 additional years of her term, was going to be dismissed from the position of the president of the Supreme Court because she just reached 65 years threshold. Okay, so that was the technique. But she said, sorry, I'm against this legislation because it is contrary to the Constitution. By virtue of the Constitution, I have 6-year term, and I'm appearing in the court on the next day. So on the day when the law was going to enter into force. But what was important, not only people standing in front of the court that were greeting her and that were supporting her, but what was extremely important was the international solidarity of judges. Because just next day, there was a delegation of the Supreme Court of the Netherlands. There was also a delegation of Amnesty International, saying that for us, Madame Gersdorf, President Gersdorf, she's still the president of the Supreme Court. We do not recognize this decision. And that kind of a feeling is the moment when Polish authorities at that time knew that they cannot make some kind of a forcible measure in order to dismiss her or to expel her from the Supreme Court. They have to accept it. So please look that this whole thing was also possible because government, on the one hand, tried to make those different liberal measures, but still it took certain care about international recognition, EU membership, presence in the UN, and so on. So for a country like like Poland, it was still important. You know, you are big, but not big enough to afford just ignoring those institutions. So then, you know, it was also a source of energy for us. So another measure like this, of this measure of solidarity, is this march of 1,000 gallons, when all the judges from all different EU member states came in order to protest together, in order to show solidarity. But please look, for them, what was especially important was that they took guns from their courtrooms. So this was quite unprecedented thing. Even by virtue of the Polish ethical regulations, it is not something you do usually, okay? Especially for the purposes of demonstrations. For other colleagues, it was also important. And but it showed that this issue of fighting for the judicial independence in Poland is not just like purely domestic issue. It is becoming like the issue for the future of Europe and the respect for the rule of law in the whole European Union.
Right. Now we're going to go to questions soon, but I want to ask you one more question, which is that this is the situation of this compromise of the judiciary, and yet the judiciary fighting back, getting support from European courts. There's an election in 2023. The peace government has been in power for 8 years. They've done a huge amount of damage in the course of that time to independent institutions and to the judiciary, even though it was fighting. The pro-democratic forces win the election in 2023, and you're named justice minister, and you're told, fix this problem. So just in a couple of minutes, if you could tell us, as justice minister, how do you unpack packed courts? How do you restore independence of compromised institutions? And how far did you manage to get? So what do you do? All of a sudden, fix this problem. Now, can you do it?
You know, we are still doing this. I mean, the same government, the same ruling coalition, and we are still devoted to do the same. I'm not any longer in the position of the Minister of Justice. There is a new Minister of Justice, Waldemar Żurek, who is one of those so-called dissident judges. Can you imagine? He was subject of altogether 23 disciplinary cases for all different statements and activities during this illiberal period. But of course, like the major idea is to propose different laws that would repair the situation, that would repair the National Council of Judiciary, the Constitutional Court, Common Courts, the Supreme Court. The problem, as well as the prosecution service. The problem is that the previous president, President Andrzej Duda, as well as the new president, Karol Nawrocki, are not very much eager to sign those laws because they claim that everything what happened in this period was basically okay from the point of view of constitution, and all those judgments of the European Court of Human Rights and the Court of Justice and all those protests of judges are more or less like a conspiracy, and basically they should not take it into account that much. We should protect our constitution, our own interpretation of the constitution, and should not be so eager to make that kind of changes. So, and to be honest, without the legislative change, you cannot achieve a sustainable effect. But still, you can do quite a lot of things in terms of making changes on the basis of existing legislation. And that is what I was doing. So, for example, those disciplinary cases against judges have been stopped. I have managed to change presidents of courts in more than 120 Polish courts. We could join the European Public Prosecution Office, which is kind of like the, let's say, name it, federal prosecution for the European Union. Thanks to certain other activities, we're also able to unblock the money from so-called EU Recovery Fund for Poland. But for me, what was also important was like kind of regaining trust of Polish people to the judiciary, but also lawyers to how the system operates. I remember one day when we've made a selection competition for the new judge from Poland for the European Court of Human Rights, which is really like a very prestigious thing, you know, to be a judge in Strasbourg is really like a great thing. And I remember that when we did this competition in a really very objective, professional way, we had 27 candidates, okay? And out of those 27 candidates, at least half of them would, you know, each of them would qualify to become a judge. And when I have seen this, you know, I could feel that, you know, sometimes change is not only about institutional dimension, but it is about regaining the trust into the system. And you regain it by certain practices, by the way you speak about things, how you are interact as executive power with judiciary, but also by transparency, and also by very complex, by taking about the legislative process. So my colleague from the government, Maciej Berek, he became like the minister responsible for the quality of the legislation and for the supervision of the government. And to be honest, I don't remember for the last 2 years any protest that would concern that we are speeding up with a certain law or that we are kind of manipulating with a certain law. So this, like the proper participation in the legislative process, is giving a chance that everybody could at least speak. It doesn't mean that everybody is heard, because quite often legislative changes require some balancing of interests. But in my opinion, taking care about different state practices, how you do things, how you operate, whether you are following certain basic standards, whether you are behaving in accordance with the with so-called procedural fairness, is also the way to make rule of law recovery. And maybe the last point, it was and it is still important for us that in this context of the rule of law recovery, we have a certain guideline to follow, and this guideline are those judgments of the European Court of Human Rights and the Court of Justice of the European Union. Because please note that we cannot rely on the jurisprudence of the Constitutional Court, because this institution has been damaged and eroded to that extent that it is not regarded as a serious judicial review institution. So we must look for some standards that we may follow in the context of repairing the rule of law.
So just to make one slight editorial comment before I go to questions, I'm going to look for hands, so be ready. One of the things you might think about Poland for Americans in the room is to say, you might be able to win an election, but unless you win all the institutions that enable you to govern, it's very hard to turn around autocratic capture. And so the Polish government has done a couple of things. One is to reverse the playbook. So at the beginning of the autocratic capture of the Constitutional Court, remember when the pro-democratic Constitutional Court was fighting back, the autocratic government didn't publish their decisions. The current Polish government is not publishing the decisions of the Constitutional Court. They were told that they had to by the Venice Commission. Now the European Court of Justice says it's okay. They're literally getting a lot of input from this court. So they're trying to figure out how to disable this packed court, and they're just not publishing the decisions. The other thing I think is just to say that legislation has been blocked all this time because the president is allied with Mr. Duda, who was here, and now Mr. Nawrocki, who is current president, will veto any laws passed by a pro-democratic parliament. And the Constitutional Court will declare other things unconstitutional. So when you get these choke points, you can win an election, and yet you don't actually win the right to govern. So, what's happened in Poland, the judges fight back, civil society has fought back, the political parties have tried to behave themselves. Like, one thing you can do when you win an election is you stop doing all those awful things the prior government was doing, which they've done, but it's not over yet. As we know from the political science literature, these so-called U-turns, democratic government falls into dictatorship, tries to come back. The U-turns almost never bring a country back to where they were at the start of the constitutional takeover. And I think we're seeing in Poland why. You're also seeing in person how wonderful the people are who have been fighting for democracy in Poland. And the struggle is still going on. Okay, so with that, we have a little bit of time for questions. I want to make sure some of you get a chance to speak. Ah, good. Yes, we have a question right here. And you have a microphone. Right here. Yeah.
Thank you so much. My name is Mackenzie. I'm a second year in the Masters in Public Affairs program.
Right.
I'm really curious about your time as an ombudsman and working in government accountability. I think we see that these institutions can often actually be weaponized against other parts of the government when a non-democratic government uses them strategically. So thank goodness you were there at the time. But I'm wondering if you've seen that since, and what other concerns you have about how sort of the fourth branch and accountability institutions can be used as part of an anti-democratic takeover.
Yeah. Do you want to take that question? Yeah. Well, maybe we should collect a couple of questions because we're short on time. So there was another hand. Where's the other hand? Over there. Yes, you. Yes, right there.
Hi, thank you very much. My name is Felix. I'm a third year in the political science PhD program here. Thank you very much for being here for your work. I'm wondering if I can ask you to speculate about whether at this point, rozliczenie or the sort of accounting for the democratic transgressions of the previous government sort of remains in the electoral interest of the governing coalition, and how to weigh sort of the electoral sort of payoffs of doing this against, sort of the possibility of if this is not sort of priority for voters or that kind of thing, the consequences of sort of the next election and what that might look like if it leads to a loss, and potentially bringing back in the anti-democratic actors from the last government.
So the question is whether you do accountability on the past government or whether you wait for the democratic process to sort things out.
That, although more so sort of if the voters would have preferred another sort of governing agenda as opposed to accounting for the previous government's transgressions,
Yeah.
how to sort of adjudicate between where to put your sort of political capital, so to speak,
Yeah.
at the risk of bringing back those former actors if it galvanizes the voters.
Yeah. Do you do normal government or do you do reparations for the past? Yeah.
Exactly.
Great. And maybe one more question. I think there was is there a hand over here? I thought there was a hand over here. Andy Morav, when Andy Moravchik's hand goes up, it's like people listen, right? Okay, Andy.
But let me ex officio thank you that Minister Bodnar met with a whole delegation of Princeton undergraduates from the school right at a very delicate time. When the Polish government was, let's just say, coming into the gray area of how to deal with migrants because of pressure from migrants being pushed across the border in Belarus. And there are people out there who don't think that the Polish government was entirely complying with international law in that situation. So this is another case where electoral sustainability and legal propriety come into conflict. So I'm wondering, with the benefit of time, what you can tell us about that decision.
Right. So 3 questions is a lot to handle. Do you want to take them in any order or?
I would like to refer just with 1 minute to what you have said in your comment.
Okay.
Because I think we should remember in the context of all those changes that these are not just institutions that are taken over or that are subject of some specific control, but there are also people who subscribe to those changes and who become part of those changes. And if there is a U-turn, if there is a pro-democratic turn, those people would not go and, I don't know, resign in some honorary way, but they would rather use their powers in order to justify their personal choices. And moreover, they have a lot of instruments to do it, because they may because quite often those changes are made in accordance with different procedural formalistic rules. So in case you want to do something regarding their position, they are using those rules in order to protect themselves, or quite otherwise they claim that they are even victims of the new regime that is coming. Okay. So, for example, even if you want to start some disciplinary case, then it appears that this case lasts for months, years, and is basically almost going nowhere when it comes to some, I don't know, prosecutors who are abusing their power, or when it comes to some secret services people or people from public media. So there are all different ways in order kind of to protect yourself against the change, but also to block the process of the recovery. So I think that we should remember about this personal element that in the context of reparatory works. Coming back to questions, I think that it is one of the strategies of the government to weaponize different institutions to target those who are against. Even quite interestingly, upon my initiative, the government has created a special committee that is investigating different forms of pressure, reprisals against civil society defenders and human rights organizations. And this committee just last week published a 500 pages long report evaluating all different forms of pressure. So SLAP litigation, so strategic lawsuit against public participation, hatred campaigns by public media, some work of prosecution service. The prosecution is suddenly interested in some specific cases, and in some other it is not interested. We have the investigative committee that is still working in the parliament, which is dealing with the use of the Pegasus spyware against attorneys, against members of the political opposition, but also even against prosecutors that were one of those, let's say, dissident prosecutors. So there are all different forms of using the state apparatus in order to target those who are against. I think the most painful one, like from a daily point of view, it even affected my family, was the public television interference in Europe, because public television became like the source of propaganda. Our good friend Wojtek Sadurski is always saying that public television was like Fox News on steroids. Okay, so more or less like this, and they were able for 3 days, produce like really like hatred content against some specific individuals, just using some factual issue and in order to presenting it in a very negative way. So that was part of the agenda. Okay, so that is why right now maybe it moves me a little bit. The question of accountability is important because there were quite many victims, and basically people expect some form of accountability. Okay, so you cannot say that we are just forgetting about those cases, we are loving each other, and we are going forward. People really suffered. There were judges who were suspended. There were prosecutors who were subject of that kind of cases. There were, teachers that were subject of some disciplinary cases for participating in some protest. There were entrepreneurs with respect to whom the pretrial detention has been abused. And basically, those people expect that there will be some process of accountability. But then the question is how to do it. Because we didn't have elections of 2023, they were historical in nature because 75% turnout, really like a huge substantial victory of pro-democratic forces. But please look, the change of power did not happen as a result, as a consequence of some kind of a revolution. You are still in the same shoes, in the same state, using the same organs. So you have the same prosecution service, you have the same courts, and they should be responsible for this. You are not able to create some kind of a special form of some, reparatory mechanism or some commission that would have some adjudicative functions, because both presidents would for sure veto it, and nobody even thought about it. Okay, so but then the question is, and basically that is one of my major problems during my service as the Minister of Justice, Prosecutor General, is how to make it effective. Because there is a huge expectation on part of the voters that you will be effective as possible regarding prosecuting, presenting charges, all different individuals that were abusing the power. But then you are facing the system in which you have to, by nature you must go in accordance with fair trial rules. Okay, you cannot circumvent the system, because then you would also abuse rules, and for sure you will end up with some failures, or even with some interim measures by the European Court of Human Rights in a situation when you would abuse rules. So and then the question is, in my opinion, that is the important political question. Okay, so if the accountability process goes forward, what is the perception of those voters that were counting on quick accountability, and that sometimes do not understand the specific character of the legal system that cannot deliver so quickly? Just look, recently we had a situation that Sarkozy has been convicted,
Right.
and it was after 10 years
10
or
years.
12 years.
The former
So
president of
even
France
in France, where you could expect that the legal system operates in a quick way, even in France it took them so many years to prosecute and to finally convict.
We're very familiar with this
Yeah.
delay of trials, and therefore we don't get.
But your question was a little bit how to shape the political agenda. Okay, I think, because it is like a relatively fresh issue, I think the government felt, the ruling majority felt that this accountability should go forward as important issue. But I think that with the lapse of time, the government realizes that it should be just one. It shouldn't be just the most important issue. It should be just one of many. And maybe right now, after 2 years from elections, 2.5, we are like getting back or going to some kind of a normality that basically those trials are going forward, prosecution is operating, some people are having their immunities being lifted, some people are having charges, cases in front of the court. So it is becoming like the part of the daily reality. But I think that the general feeling is that they don't go unpunished, okay? Because at the end of the day, they have their cases before the courts, and those cases are reviewing those cases, and I think that we'll have sooner or later some convictions. And the last question
Only
concerning.
a couple minutes from the end, so I know you could talk about it for a long time, but go ahead.
Yeah. No.
Yeah,
Just shortly.
But it's an important question to raise.
It is extremely important question. Okay, so please look that Prime Minister Donald Tusk had this like very important decision to make, what to do with the Polish-Belarusian border situation, where we had a problem that every day 300, 400, 500 people were trying to cross the border. And they were not trying to cross the border just because of some spontaneous effort of getting to Belarus and trying to go through the forest, to Białowieża forest, but because they were brought there by Lukashenko, by Belarusian authorities from different countries, mostly from the Middle East. So what appeared was the problem of so-called instrumentalization in order to destabilize the situation in Poland. And in other countries of European Union. So there was the attempt to create like additional alternative migration route. And Prime Minister made a decision that the procedure of pushback should be used as I would say, standard measure, with certain exceptions, that it should not apply to people who are identified as being persons with disability, women with children, pregnant women, so those vulnerable categories. So with respect to those people, this procedure should not apply, but with respect to other procedures, it should apply, and moreover, the fence should be protected, okay? The end result of this policy is the protection of the border in 98%. So there are almost like a very relative small number of people crossing border. And of course, it created a controversy and is still creating from the point of view of human rights and from the point of view of Geneva Convention and the European Convention on Human Rights. But I think what was important in this regard was the communication that has been made in December 2024 by the European Commission, in which the Commission said that member states have a right to protect its borders against weaponization, and the word weaponization of migrants has been used. And basically, the Polish practice is right now more or less the same as the Finnish practice and as the Finnish law that has been created. It was not an easy decision. It was also not an easy moment for me when I was in the government, but I do my best to understand the political reason behind this decision.
Well, we've been talking very fast for an hour because there's so much to say. There's so much more to say. Minister Bodnar will be here actually also today and tomorrow. We have some meetings with students set up, and if any of you are interested in seeing him at some of those meetings, please let me know. We can slot you in. But in the meantime, we're just really grateful that you could come to Princeton, and really grateful for all of your service for democracy and rule of law in Poland. So thank you so much.